A prenuptial agreement is a contract written before a marriage that defines the terms of the divorce to foresee a positive outcome for both spouses in the event of a dissolution. A postnuptial agreement is a simple prenuptial but written after a marriage is performed. Typically, a prenup or postnup protects significant assets one spouse brings to the marriage. Some examples of this are real estate, such as the primary residence or vacation home, inheritance, a family business, and investments. There are many reasons a couple may decide after being married that they should draft a legal agreement about the division of assets and other issues in case of a divorce. Sometimes a couple simply waits until after they are married to sit down and go through the process together. Often, it is because a couple has worked through a rough patch and decides to create this insurance for themselves while they are in a good space. In a contentious divorce, one spouse may challenge a prenup or postnup. It is possible that a judge could throw out some or part of an agreement that was not drafted properly. Florida law requires that prenuptial and postnuptial agreements meet certain criteria to be valid and binding. These criteria include: the agreement must be in writing. Oral prenups and postnups are not enforceable. The agreement must be witnessed and notarized. Parties to the agreement must be married. A prenup does not become effective until the parties are legally married. The agreement must be voluntary. A court will rule an agreement invalid if one spouse can prove that he or she signed it due to coercion, force, or undue influence. The agreement must be equitable. An agreement that is grossly biased in favor of one spouse would be unlikely to withstand a challenge. If you and your spouse are considering a prenuptial or postnuptial agreement, contact us to ensure you and your assets are protected as you move forward.